Okay, the next case we have is Bonnie Carrasco versus Samuel Strader. And y'all had a request to take this off the YouTube? Is that correct?
I did, Your Honor. But
Okay.
if it's gonna obstruct procedure, then we can proceed.
No, I just need to know the reason.
The reason is invasion of privacy.
Okay, because Texas courts are considered public.
Okay, well, if anybody wants to obtain public record to these proceedings, they can do so, but they don't need YouTube to do it. Am I wrong?
Before we even get into the chaos today, buckle up, because this case is a perfect example of what happens when family, money, and ego collide in a courtroom. We've got a mother claiming she loaned her own son $10,000, a son insisting it was a gift, and absolutely zero paperwork tying this mess together. Instead of contracts, we get screenshots. Instead of legal strategy, we get Google lawyering. And instead of calm testimony, we get raw emotion, accusations, and enough personal attacks to make this feel more like a Thanksgiving blow-up than a civil case. This isn't just about money, it's about pride, control, resentment, and a total breakdown in communication. You'll hear arguments about gifts versus loans, text messages being treated like binding contracts, and both sides leaning hard into their own version of the truth. And just when you think it can't get messy, remember, this is only the first case. We still have a sovereign citizen courtroom meltdown coming later. So stay locked in because this one spirals fast, and the judge is not here for the nonsense.
Well, see, because we're doing it over the video and not in a courtroom, we have to have some way to make it public. And so that's what they came up with, was to just put it on YouTube. It's not being recorded.
Yeah, I mean, I guess I understand that, but not really, but that's fine. We can proceed.
Okay. Let's see, Ms. Carrasco, and Mr. Strader, let me swear y'all in. Do each of you swear to tell the whole truth and nothing but the truth?
I do, Your Honor.
Okay. And Mr. Strader as well?
Absolutely.
Okay. Now, Ms. Carrasco, I've been through the evidence that y'all submitted and the petition, and I know this concerns a loan that was made on November 6th of 2023. And the contention you're making is that it was a loan?
Yes.
And you've been trying to collect on that loan?
Yes.
When was the first time that you, if you can recall, as I said, that loan was in November of 23. When was the first time that you made an effort to try to collect on that or talk to your son about collection on that?
In February.
In February of 24? Okay.
Yes.
And
also, Your Honor, I'd like to point out that any reference to my medical condition should be stricken from the record. He had no business admitting it. He is not a trained psychologist.
Right. That's not relevant. It's not
correct.
Relevant. So that was in February.
Yes.
And what other efforts did you make besides the
well, I can tell you this. 2 days after we filed the court almost a year ago, he came into my house intoxicated with George Ferguson and said, "Meet me at the bank." 2 days after he was served.
After he was served? Okay, because this was filed on March 21st of 24.
Yeah,
so
he came in, and once the constable served him, he arrived at my house, said, "Meet me at the bank," said an F word to George Ferguson, and said, "Meet me at the bank tomorrow. You sent the police to my house." The day after he was served.
The day, okay, and what happened then?
I said, "I don't need to go to the bank. You're intoxicated." You said, "F you to George." There's evidence said we can have a civilized conversation. I said, "Go in my bank," because he banks, Your Honor, where I bank, and deposit the money or make a payment plan. I also, on July 10th, Your Honor, I know there's a lot of evidence. I offered him a settlement.
I read that.
Of $150 to 100 a week. He works for the city of Austin, making
Right.
$62,000 a year. Plus, and took another $10,000 loan that he showed me on his phone to use as, quote, a cushion, Your Honor. A cushion.
This right here is a moment that trips up a lot of people who walk into court thinking they can control the narrative. Court proceedings are public, full stop. Once you file a case, privacy becomes a luxury you no longer own. It doesn't matter if it's uncomfortable, embarrassing, or family related. Courts exist for transparency, not protection of feelings. And the judge explains this pretty clearly. YouTube isn't the issue, it's simply the platform Texas courts chose to make proceedings accessible. What's interesting is how quickly frustration turns into hostility. Instead of focusing on the legal issue, whether this money was a loan, emotions start taking the wheel. Insults creep in, defensiveness spikes, and you can already feel this case drifting away from evidence and toward personal grudges. That's never where you want to be in front of a judge. Courts don't care about vibes or intentions. They care about proof. And right now, neither side seems prepared to deliver that cleanly.
Well, his finances are his own business. He didn't accept the settlement. That I know that happened.
Correct.
But
Now, if you look at Sunday, February 18th, I need $250 by the 1st. I'm fat effing broke. I apologize for my language in advance. You agreed to make a payment plan, and I haven't seen your payment. So what is your plan? You also have Aaron or Paula call me at the bank, because he banks where I bank, Your Honor. By the way, this is Sammy. This is business. He says this is extortion. This is him talking to his own mother.
Is that filed in the exhibits that you sent?
Yes.
Which one is that in?
By the way, this is extortion. It's February 18th to Saturday, March 23rd at 4:16 p.m.
Well, it's first you sent in that plaintiff's exhibit packet, and then you sent in plaintiff's account history and loan and security agreement. And that bunch of evidence. Do you know where it is?
What do you mean?
What you're quoting from, the extortion statement. In which of those exhibits is it in?
It is dated Saturday, March 23rd at 4:16.
I just don't.
It's a text message.
Right. I don't remember reading that part.
I can show it to you. It's right here, Your Honor.
Pardon me?
Can you see it?
Oh, okay. Okay. See, I just don't remember. Okay. Go ahead.
So hold on. Can you see where it says this is extortion?
Yeah. Okay. And that was February 18th?
March 23rd.
Oh, that was March 23rd. Okay. Go ahead.
This exhibit, Your Honor. Can you see it, Your Honor?
Yeah. Go ahead.
Can you see what he's saying?
Yes. Now that one I saw.
Can you read that for the court, please? And on the record?
Oh, it's in there. It's in the.
I'm going to nominate you for Mother of the Year. No arrest in 13 years. Wow, it's really amazing how much you want to help your mom, who gave you 10 grand. Let me emphasize the word gave, Your Honor, with all due respect. The bank gave me a loan. Gave does not constitute, the word gave in legal terms does not constitute gift.
Right. Okay, go ahead.
So, will you accept half or not? Do you see that, Your Honor? If it's not a loan, why are you accepting half? Because the burden is on me, or the burden is on him to disprove this.
This is where timelines start to matter a lot. The court isn't just listening to what happened, but when it happened. The loan was allegedly made in November, but the first attempt to collect doesn't happen until February. That gap alone raises questions. Judges look closely at behavior patterns. Did you treat this like a loan from day one? Were their payment terms discussed early? Was repayment expected immediately or eventually? Then we hear about the defendant showing up intoxicated after being served, which, even if true, doesn't actually help prove the loan existed. Courts don't rule on vibes, fear, or how someone made you feel. They rule on agreements. Every extra detail that isn't tied directly to the loan risks muddying the waters. Emotional context might explain why things broke down, but it doesn't establish legal obligation. This is where cases are often won or lost, not on outrage but on clarity.
You see this text message, Your Honor?
Yes, yes.
That's coercion. No arrest in 13 years. He did a background check on his own mother when he's a convicted felon.
Well, we're just talking about the nature of the loan right now.
Correct. You see this, Your Honor? He banks where I bank. I called my bank. They said, you don't need to go into the bank with Sammy because, frankly, he scares me. I don't even want to see his face during this. I'm a nervous wreck. I said, Paula or Aaron, call me because he banks where I bank. And you don't even need to be here. We'll put the money in the bank. He did not.
Okay.
And P.S.
Okay.
Ask him why he borrowed 10 grand. Ask him how much he spent on his wedding. Because I know.
Well,
and I believe, Your Honor, with all due respect, this should now become a community debt should I win the case.
Here's the problem with relying on text messages as your entire case. Texts are messy, emotional, and rarely precise. One message can sound like repayment, another can sound sarcastic, and suddenly the judge is left interpreting tone instead of enforcing terms. The plaintiff keeps pointing to phrases like, "I'll pay half" as proof, and yes, that does hurt the defense. Offering repayment implies obligation. That's a big deal in civil court. But this entire situation could have been avoided with a single-page written agreement. No notarization. No lawyer. Just basic terms. Instead, both sides are now fighting over interpretations, intent, and selective screenshots. Judges hate that. This is why courts constantly remind people. Informal agreements between family members are the fastest way to end up in a courtroom with everyone angry and nobody satisfied.
No, it's what it was at the time of the making.
Okay, you see this exhibit, Your Honor? I'm willing to do this out of the goodness of my heart. Really? Really?
Okay.
Another admission. You see this exhibit, I told you, pay house, buy house, give back, or pay bills. Now, if defendant offered me 10 grand, Your Honor, I apologize for shouting. You see how bad I'm shaking. Why would I say, oh no, Sammy, I don't want your 10 grand. That's an outright lie.
Okay.
And you have no case. This is his arrogance. And we're just about done here. You see this exhibit? I'm willing to have a civilized conversation about this without your bodyguard. That was George. When he walked in and said, fuck you to George. You see this? You are a psycho narcissistic. Read that, Your Honor. With all due respect. You're going to talk this way to your mother who let you live here and walked out of my house with $15,000.
Okay, we're just gonna talk about the
I
loan.
understand.
We're not gonna talk about the tenor of his other statements, just the loan.
Again, Your Honor, at the bottom, I am willing to pay half.
Mm-hmm. Mm-hmm.
Again, Your Honor, show his arrogance. Your first mistake is thinking you can tell me what to do. You see it?
See, that's what I don't want to hear stuff like that right now. I just want to hear about the nature of the loan.
Okay. Well, I think I've submitted enough evidence. Do you have any questions for me, Your Honor?
No, not at this time.
Thank you.
But you are requesting return of the $10,000. That's what you're asking the
I'm
court.
willing to settle the case right now today for $5,000.
If he wants to do that for $5,000.
Yep, that's giving him half. Oh, one more thing.
Mm-hmm.
That he's taunting me. Free legal advice is nice. Who does that to their own mother, Your Honor?
One of the most common mistakes people make in small claims court is thinking income equals obligation. How much someone earns, what they spent money on, or whether they should be able to pay is mostly irrelevant. The court isn't here to redistribute fairness. It's here to enforce agreements. Whether the money went to a wedding, bills, or a so-called cushion, doesn't answer the legal question. And once personal insults enter the record, credibility starts slipping. Judges notice when testimony becomes emotional instead of factual. Every dig, every exaggeration, every unrelated accusation pulls focus away from the actual issue. Was this money loaned with an expectation of repayment? Courts reward restraint. The calmer, clearer party usually wins, not because they're right emotionally, but because they stay legally grounded.
I know it's irrelevant, but not to me. Do you realize
Okay.
what that's done to me? Look, I'm shaking.
Okay, try to relax. Okay, just try to relax. Mr. Schrader, she says she'll settle for $5,000 right now.
Yeah, I hear her.
Yeah, again.
Is she going to unmute or is she going to mute?
Yeah, let's talk to Mr. Schrader right now, Ms. Carrasco.
Sure.
Go ahead, Mr. Schrader.
I'll be happy to answer any direct questions, but my testimony has not changed.
Well,
This was never a loan. I mean, if you want some background, I can give it to you.
well, first I want to know if you accept the offer.
No.
5,000. Okay. Okay, go ahead.
Do you have any questions, direct questions for me, or do you just want me to do what she just did and tell you the whole story?
I just want to know the kind of the presumption in law is that it is a loan. You
By
need to
whose
establish it was a
standards?
gift. That's the legal,
I mean, how has this been proven a loan thus far?
because she is indicated that it's a loan. She says it was a
Okay.
loan.
Okay, but it's my word against hers, right?
Well, that's why I'm saying the legal presumption is that it is not a gift. And you need to tell me how it is a gift.
Okay, because she told me to keep it on the phone, which is on record with Consumer Cellular, which unfortunately you can't subpoena phone calls because this is not Law and Order. This is not TV.
Right.
However, that's how it went down. $10,000 to a guy like me is life-changing money. And she also left out the part where she had a house picked out on Oak Alley right around the corner from her house for $450,000. And I quickly assessed the situation and said, there's no way possible that you can buy a house in Austin, Texas for $450,000 with $10,000 down. So I said, we're not buying a house. I'm 53 years old. I'm not hitching myself to a mortgage. And it's impossible to do with only $10,000. So I can either pay off some bills with this or I can give it back. She said, keep it. It's a gift. She was happy. She was living her life. She was doing her thing. She was spending money all over the place. And I was happy for her. I was like, well, maybe it'll stick. And it didn't. So, I mean, if you read the evidence that I submitted, the letter that I wrote to the court, it's almost verbatim. You don't have to remember anything when you're not lying. This is actually what happened. And then right after that, she said, don't tell Ben. Ben is my brother. He's a very successful family court lawyer.
Mm-hmm.
And she said, don't tell him. And I said, well, that's no problem. We never talk.
Mm-hmm.
What does she do 2 weeks later? She tells Ben. Ben goes ballistic because he's entitled, he's selfish, and he's greedy. He says, where's my 10 grand? And if he was here today, if he was sworn to tell the truth, the whole truth, and nothing but the truth, he would admit to that statement. Now, why would he make that statement? Why would he say, where's my 10 grand?
Well,
If it was a loan, why would he say, where's my 10 grand?
we're getting into hearsay here, so let's just
Yes,
talk about the things that we know about. Not
This
what-
whole case is hearsay, Your Honor. This whole case is hearsay.
No, statements that the parties make are not hearsay.
Is there a contract with my signature on it, agreeing to terms of a loan or to agreeing to making payments?
This is the defense's core argument, gift versus loan. And legally, this is an uphill battle. In Texas, money exchanged between parties is presumed to be a loan unless proven otherwise. That means the burden shifts to the recipient to show it was a gift. Verbal claims, feelings, and character statements don't cut it. You need evidence, something concrete showing the giver intended no repayment. The explanation about phone calls that can't be subpoenaed, background family drama, and third-party reactions doesn't actually help much. Courts don't rule on hypotheticals. They rule on what can be verified. And the moment the defendant admits to offering partial repayment, even if emotionally motivated, that presumption becomes harder to overcome. Intent matters, but actions speak louder.